Hello friends, I hope you all are safe at your home with your parents. And in previous lecture we have learned about the transfer of the share and the whatever the instruction slip, the example of the instruction slip as well as the transfer procedure we have learned in the detail. Now we are going to learn about the duties of the secretary for the share transfer in this video lecture. Now we are going to continue it. Now, this one is the duties of the secretary for the share transfer and which may ask in a 3 or 4 mark questions. So you have to tick mark it. Now, duties of the secretary for the share transfer. First of all, transfer of the share is transfer of ownership. See, transfer of the share is the transfer of the ownership right. The secretary has to perform his duty properly. See, it is the one kind of transfer of the ownership. So that's why the company secretary has to follow the rules and regulations and perform his or her duty perfectly, very perfectly, because there is no chance to remove or no chance to any kind of ambiguity. So we have to be careful. He has to look after the transfer of physical share. See, it is the responsibility of the company secretary that he or she has to completely look after the whole procedure of the physical transfer of share. There should be no litigation in future, nor should the provision of the Company Act 2013 be ignored. See, no litigation. Litigation means any kind of court matter is not necessary. See, company doesn't want to face a single time any kind of court matter because it is a harm for the company's prestige. That's why company secretary has to be proper in his or her duty that so that the company doesn't want to face any kind of litigation as well as the violation of the rules and regulations of the Company Act 2013. That's why company secretary has to perform his duty perfectly regarding the share transfer procedure. If such provisions are ignored, then secretary and other responsible persons found guilty can be punished. See, if any kind of rules and regulations be breached or violated, at that time the person who is responsible for that is to be punished. First of all, to verify the share instrument and transfer form. See, this is the now we are going to learn the steps which completely company secretary has to follow or be ready or be punctual in that particular matter. So now we are going to learn about this, that to verify the share transfer instrument, the very first step that company secretary has to perform, that is the verification of the transfer instrument as well as the transfer form. Secretary has to verify the share instruments carefully. See, company secretary has to verify the instrument, or you can say the transfer form, perfectly. He has to verify the number of share, types of share, signature of shareholder, and other essential details as per the provision. See, company secretary has to verify the number of share, type of share, and signature of the shareholder compulsorily, because no any single procedure should be compelled with the any kind of violation of the rules and regulations. Next one is the stamp and fees. Secretary has to verify market value of the share mentioned in share transfer form. See, the company secretary has to see the market value of the shareholder, that this type of market value and mentioned share are transfer which are very perfectly or not. It is necessary that company secretary has to check all the necessary details. He has also verified whether the stamp duty affixed by shareholder is according to the value of the share. See, it is the most essential duty of the company secretary that he or she has to completely check that the stamp duty are affixed as per the market rules or not. It is very perfectly, and they have to compulsorily see this kind of step. Next one is the signature of witness. Signature of witness is essential. See, without the witness signature, it is not valid. Secretary has to see and ensure the signature of witness. See, company secretary has to see that the signature of witness is mentioned properly or not. Next one is the receipt of share transfer. After receiving the share transfer form at the company's register office, a receipt shall be issued provided all the details are satisfactory. See, if transfer form received by company secretary and all the necessary details are completely verified and satisfactory, at that time company secretary issue a one kind of receipt for the share transfer procedure. It is a one kind of evidence that the transfer instrument of particular person's share transfer is reached at the company's registered office, so that it is very properly and should be a very perfectly, and it is a one kind of evidence that all the details which you have mentioned in the company's receipt or in the company's share transfer instrument and all the necessary details are satisfactory found. Next one is the resolution of board of directors. If information provided in the transfer form is found to be satisfactory and correct, then share transfer is approved. See, if all the information provided in the share transfer form is found satisfactory, at that time it is necessary that the receipt should be given to a particular person and the transfer can be approved. A resolution regarding the approval of share transfer is passed in the board of directors meeting. See, resolution should be passed in the board of directors meeting. If resolution should not be passed at that time, company cannot go for the further procedure. Entry in share transfer register. After getting After granting share transfer, necessary entry is to be made by secretary regarding share transfer. See, after granting share transfer, if approval of the share transfer is generated in company's meeting, at that time company go for the further procedure and make it very perfectly, and the transfer is passed, and the entry should be made in the share transfer register. Registration in register of members. Share transfer is approved on the basis of the form of the transfer presented by the shareholder. See, transfer form is approved in the meeting of board of directors. At that time, form of transfer presented by the shareholder that they want to transfer their share. It is followed by the necessary entries in the register of member. After getting this type of form, all the necessary details should be registered in the register of the member. To issue the notice regarding the approval of the share transfer. After approval of the share transfer, notice is issued to share purchaser and share buyer. See, after the whole procedure completed, at that time notice should be issued to both the parties, that is of the purchaser and share buyer, so that the whole procedure should be generated and converted very perfectly and carefully. એક જ મિનિટ આપું છું. Now, to issue notice regarding the approval of the share transfer. After approval of the share transfer, notice is issued to share purchaser and share buyer. See, after the approval of the share transfer is given, notice should be issued to a share purchaser and share buyer. Now, to prepare a share certificate. After the approval of the share transfer, it is a duty of secretary to prepare a new share certificate for the new shareholder. See, if the approval of the share transfer is generated, approved, it is the duty of the secretary that to prepare a new share certificate for the new shareholder. To issue share certificate to new shareholder. After new share certificate is prepared, new shareholder is informed to collect the share certificate as per the receipt issued earlier. As per the receipt given by the particular person, the secretary has to inform new shareholder that to collect the share transfer certificate. Share certificate is prepared by the company and they have to collect it. The share certificate can also be dispatched to the address as per the receipt. See, if person is not able to collect the share certificate from the company's office at that time, the share certificate is dispatched as per the address mentioned by him or her in the company's registered office. Next one is to observe the provision of the articles of association. The secretary has to confirm himself that no provision of articles of association have been violated in this transfer. See, it is very necessary that they have to compulsorily give a legal notice that they have not violated a single rules and regulations in the transfer procedure, and also they have to seriously observe the articles of association and its provision, and it is very necessary part, and they have to compulsorily mention this while they are going to transfer and approved in the company's transfer procedure. Now the next topic we are going to learn is that the transmission of share. Now the meaning of the transmission of share. When the ownership of share is transferred compulsorily under any law, then such a transfer is known as the transmission of share. See, when ownership of the share is transferred compulsorily according to the law, according to the law and according to the rules and regulations of the Company Act, at that time such transfer is known as the transmission of share, and it is compulsorily should be transferred while during the complete procedure, and it should be followed strictly. Meaning, when the title in share of a person is automatically transferred, it is called the transmission of share. Means whenever a person's name share should be transferred compulsorily, at that time it is known as the transmission of the share. Shares are to be transferred under the operation of law when the shareholder is declared to be of unsound mind or declared to be insolvent, or in case of his death. See, the transmission procedure should be followed when the person of or a shareholder is declared unsound mind, declare insolvent, or in case of the death. It is compulsorily the transmission procedure should be followed. Now, circumstances for the transfer of share under the operation of law. See, under operation of law means the transmission procedure. First one is the this may ask in a 3 or 4 mark questions that you have to compulsorily tick mark it very properly. Very first thing is that the will is not prepared and there are legal successor. See, will means a single one kind of document of the, or you can say it is a one kind of statement of the assets for a particular person, and the person have not prepared the will and he have a legal successor. Sometimes shareholder has not prepared will and he expire, then the share in his name are transferred to successor on the basis of the succession certificate. See, if any shareholder who have a share and he or she has not prepared a will, but he or she have a one kind of legal successor, at that time the whole shares are transferred to that particular legal successor as per the succession certificate. If that particular person present a succession certificate, at that time the share is transferred automatically to that particular person who is the legal successor of a shareholder. Next one is the will is not prepared and there are no legal successor. See, the second case is that will is not prepared and legal successor is also absent. Many a times shareholder has to prepare a will and he has no successor and he expires. See, sometimes any person has not presented his will and also he or she has no legal successor. At that time, what should be going on? In this situation, the court may appoint the administrator or you can say receiver. This is the another name of the administration, who then has the right to conduct. The court may appoint the administrator or receiver. Means a person who is known as the administrator or receiver is that the near relative of a particular shareholder. At that time it is necessary that company uh, appoint or company find that particular relative as a administrator or receiver of that particular person who is the shareholder of the company. Say for example, here I give you one kind of example, that is that a person namely A is the shareholder of the company. Now he has not prepared will as well as he have no successor. Now what happened? The person namely B is the near relative of shareholder A. Now court may appoint this person as a administrator of a particular shareholder of A. Now it is the responsibility of person B to observe all the transactions regarding the share of a person A. Now a person A is died. He has not prepared will and have no legal successor. So that court may appoint person B as administrator of A. Now the all responsibility of B to observe the transactions of A. In case of that, will is not prepared and there is no legal successor. Clear that? Now next one is the shareholder declared to be insolvent. See, now person is declared insolvent. When shareholder is declared to be insolvent by court, an official receiver or assignee is appointed by court. See, this is the another case where administrator or receiver is to be appointed. When a person is declared insolvent, at that time court may appoint a particular person as a receiver or administrator. The shares are transferred the name of the official receiver. Now all the shares should be transferred of that particular person who is appointed as a administrator of insolvent shareholder. For this, the receiver has to present an appointment letter given by the court. See, court has given a particular appointed letter to a particular person who is a receiver of the company. At that time, he or she has to present a letter given by court as a appointed as a receiver of particular insolvent shareholder. Now, shareholder declared to be lunatic. Lunatic means a person with unsound mind. It is another name, another word. That is, the lunatic means a person becomes a unsound minded. In simple word, gando. When a shareholder is declared to be lunatic of unsound mind, a guardian or trustee is appointed by the court. See, a person is appointed as a say for example, a person who is a shareholder of the company, but due to unnatural condition, that particular person become a lunatic mind. At that time, the company or court may appoint guardian or trustee. See, here two different words are mentioned. The very first is that the guardian. Guardian means a person's mother or father is available and person become a lunatic. At that time, that particular person's mother father is available. At that time, they are appointed as guardian. Now, second case, if person become a lunatic, but say for example, the person become a lunatic due to unnatural condition and his father and mother is not available, but person is married and his wife is available. At that time, the wife of that particular lunatic minded person is known as the trustee. Very first case is that the person's mother father is available. At that time he can be appointed as a guardian. But in second case, if their mother father is not available, at that time wife or other persons are appointed as a trustee. Such a guardian or trustee present the appointment letter issued by the court to the company. See, company has to that particular person has given a appointed letter by the court that they are appointed as a guardian or trustee. After receiving such a letter, the shares are transferred to the name of the administrator. See, all these shares are transferred in the name of the guardian or known as the trustee. Now, death of a person in case of a single person company. On the death of the sole member, the person nominated by such member shall be recognized by the company and the company will transfer all the share of that member. See, the person who is the shareholder of the company and all of a sudden he died. At that time, nominated person is given the necessary charge of the share. A legal representative has the right to get a dividend and other privileges. See, the all legal successor have a right to present this type of information or the shares. However, a representative cannot participating in the meeting of the company. He cannot utilize the rights which are given to the shareholder. See, they have no right to remain present in the meeting of the company as well as such rights. Some limited rights should be given to a particular person for their the advantages of a particular person's shares are transferred. Now the procedure is mentioned over here, but it is necessary that before that you have to compulsorily see that the whole the transactions of a particular word or particular topic which are very important. See, in procedure we have to compulsorily see very perfectly. If you people are not able to watch or understand the procedure perfectly, at that time you will not be able to understand the further topics which are very important as far as your examination is concerned. So I request you all to kindly watch the video up till the end while it is necessary. See, if you people feel that the sir is telling again and again that you have to compulsorily watch the video perfectly up till the end, but so many students are found that they are not observing, they are not watching the video up till the end. So that what become, you people are not able to see video perfectly up till the end. At that time what happen, if I urge to make or ask any kind of doubt, at that time you people have a zero. Why? Because you have not seen the video perfectly. Then what happened? Now you have no idea that what type of question should be asked or what type of doubt should be raised in the lecture or scenario of that particular video lecture. But if you have seen that particular videos up till the end, make sure such doubt should arise. But it is happen that when you have observed the videos very carefully, at that time this may situation arise, but you have not seen the video perfectly, at that time this situation may not be arose. So I request you all to kindly watch it very carefully. Now in that case, the circumstances may ask in a 2 or 3 mark question, and the meaning of the share transmission, it is also asked in a 1 mark question. So you have to tick mark it in your textbook if in physical form is available, and the textbook is not available in physical form. At that time I request you all to kindly note down the topic name in your notebook for your examination as well as the preparation is concerned. So while you going to read or be prepare for your examination, at that time this may be helpful. So I request you all to kindly note down that the topic is that the second thing is that the circumstances for transfer of the share under the operation of law, which may ask in a 3 or 4 mark question. So if you have noted it, at that time you will be able to be careful while your preparation is going on. See, if the information is not available at the time of preparation, at that time you will not be able to be ready for your preparation as well as the examination is concerned. And the another topic that we have learned, it is that the duties of the secretary regarding the share transfer. These may question asked in a 3 or 4 mark questions. So while you have to be ready for your examination and preparation is concerned, so if you have noted it very perfectly, at that time you can be ready for it very easily. But whenever you have not observed it very perfectly, at that time you will not be able to go for the further procedure as well as the preparation is concerned. So I request you all to kindly watch these videos very carefully up till the end and perfectly. And if you are not able to watch it very carefully, at that time make sure you will not be able to write a single word in your examination, as well as you cannot ask a single doubt from there. So I request you all to kindly watch it very carefully and be ready for your examination is concerned. See, here some topics are removed by the board, but we have to learn it very carefully because it is a one type of concern for future topics. So read it very carefully, see it very carefully up till the end. Thank you very much.